Welcome to Law Minds. Today's topic is Inherent Powers of Court under CPC 1908. So, first of all, let's dive into what is the definition of the word inherent. So, the first point is existing as a permanent, inseparable attribute. Now, what does that mean? The word inherent means that is something which cannot be separated or which is termed to be permanent. So it refers to something that is essential or a characteristic attribute with something else, often in a permanent or an inseparable manner. Now the second point, the inherent power of the court. The first point states that it is not explicitly conferred by the statute or laws. And the second point is that the essential for the court to fulfill its duties of delivering justice effectively. Now what does this mean? So there are certain abilities or authorities that the court inherit which it possesses to ensure that the justice is served. And even when the specific provisions or guidelines are not outlined in the law, these powers allow the court to act in certain situations where there might be gaps or deficiencies in the existing legal framework. So the court is allowed and possesses the power in order to ensure that the justice is served. Now, what are the purposes of inherent powers? The first one is that it ensures justice is served comprehensively. And the second point is that address gaps or deficiencies in the legal framework. So, as we have said earlier, this power or the inherent power of the court is to make sure that the justice is served, and if there is any gaps or deficiency in the existing legal framework, then the court can use this power to fill those gaps. Now coming to the fourth point, that is section 151 of the Civil Procedure Code. The first point is that it deals with the inherent powers in civil procedures. Second point is that it grants courts discretions to make orders for the ends of justice. So this section deals with the inherent power of the court in civil cases, and it also grants the court discretion or the power to make orders or judgment to meet justice. Now let's look into what are the provisions from section 148 to 153b of CPC. So the law relating to the inherent powers of the court is mentioned in section 148 to 153a of the Civil Procedure Code that deals with the exercise of powers in various situations. So the following are the provisions. Section 148 and section 149 deals with the enlargement or grant of time. Section 150 deals with the transfer of business. Section 151 protects the inherent power of the court. Section 152, 153 and Section 153A deals with the amendments in the decreased judgment order or in separate proceedings. Now we can look into each one by one. So the first one is enlargement of time, which is given under section 148 of CPC, and it states that where any term is fixed or awarded by the court for doing an act provided by CPC, it is the discretionary power of the court, and the court may enlarge such period from time to time, even though the term originally fixed or awarded may have departed. So this means that even though a term is fixed by the provision for doing an act, the court has the power to extend that period of time up to 30 days. So the power is exercisable in the deficiency of any provision which is contrary or which reduces or withholds the period. So the power is limited to the extension of the time fixed by it, and it is the discretionary nature of the court. This section is the payment of court fees, section 149 of CPC. Now this section says that where the entire or a portion of any fee commanded for any certificate by law for the time being in force relating to court fees has not been met, the court may in its discretion at any step permit the person by whom such fee is payable to pay the whole or part, as the case may be, of such court fee. And upon such payment, the document in regard of such fee is payable shall have the same force and result as if such fee had been made in the initial situation. So let's look at this at a simplified version. So This section says that the court can allow a party to pay the court fees late, even after the time limit for filing the lawsuit or appeal has been passed. So, paying the court fees is necessary for any court related document. And if the court fee is paid within the court's given time, it is not considered as late. So, late payment can fix a document that was initially flawed, and the court has the power to decide on late payments. But it should only be done in the interest of justice. Now, the next one is transfer of business. Now, this is given under section 150 of CPC. Now, what does this section say? Save as otherwise granted, where the business of any court is assigned to other court, the court to which the business is so assigned shall have the same authority and shall make the same duties as so sequently presented and forced by or under this code upon the court from which the business is so assigned. So, in simple terms, if one court transfers its cases to another court, the court which receives the case has the same authority and responsibility as the transferring court. So, the receiving court must handle the transferred cases according to the same rules and duties outlined by law. Now, this is what the section says. So, now coming to section 151 of CPC, which deals with the saving of inherent powers of the court. Now, this section says that nothing in CPC shall be considered to restrict or otherwise affect the inherent power of the court to make such orders as may be important for the ends of justice or to limit the abuse or method of court. So, in similar terms, this section states that it ensures that nothing in civil procedure code limits the court's inherent powers. The court can make orders which are necessary for justice and to prevent any abuse of the legal process. The court also does not have to wait for new laws or orders from the higher courts to act, and it has the discretion to act for the sake of justice and to prevent the misuse of legal system. Now let's dive into what are the limitations. So the exercise of inherent powers carries with certain restrictions or barriers. So let's look into each one of them. The first point is that they can be applied only in the deficiency of particular provisions in the code. So they can only be used when specific laws are lacking. Now the next one is that the it cannot be applied in dispute with what has been expressly given in the code. So it means that it cannot contradict what is explicitly stated in the law. Now the third one is that they can be applied in rare or exceptional cases. So they can only be used when there is some, we might say, like the rarest of rare cases or some exceptional cases, only these inherent powers can be used. So the next one is while operating the powers, the court has to follow the method shown by the legislature. Now this means that the court must follow the legislative guidelines when using them. Next one is the court can neither exercise jurisdiction or entrust in them by law. Now this means that the court can't create new legal jurisdictions. The next one is that to abide by the principle of res judicata, which means that not to open the issues which have been already decided by the court. Now this says that it must respect the principle of res judicata, and it cannot go beyond that. And the next one is to pick a mediator to make an award afresh. Now this means that they can appoint or a mediator to resolve disputes. Now the next one is the substantive rights of the party shall not be taken away. Now this means that they can't infringe on substantive rights of the parties. And the next one is to limit a party from taking proceedings in the court of law. So they cannot limit or restrict the party from filing lawsuits. The last one is that to set apart an order which was valid at the moment of its issuance. This says that it cannot revoke an order if the circumstances change. coming to conclusion. So inherent powers are the powers of the court which are helpful in minimizing litigation and avoiding the multiplicity of proceedings and to render complete justice between the two parties. These provisions